A pleasant day to everyone. For today's lecture, we will be discussing the distinctions between a contract of sale and a contract to sell. At the end of this presentation, we hope that you will understand the difference in the legal effect between a contract to sell and a conditional contract of sale, as well as distinguish one contract from the other. This presentation was prepared by Lumina Aquino, Aliana Bantolo, Zachary Duquilla, Giselle Francisco, Michelle Chu, and Jason Chu. What is a contract of sale? In Valdez v. Court of Appeals, the court held that a contract is one of sale absent any stipulation therein, first, reserving title over the property to the vendee until full payment of the purchase price, and second, giving the vendor the right to unilaterally rescind the contract in case of non-payment. What we can derive from the provisions of the Civil Code as well as jurisprudence is that in a contract of sale, title to the property passes to the buyer upon the delivery of the thing sold. Further, the seller loses ownership over the property and cannot recover it until and unless the contract is resolved or rescinded. Whereas in a contract to sell, title is retained by the seller until full payment of the price. Further, ownership is reserved to the seller and is not to pass to the buyer until full payment of the purchase price. The court's ruling in the 2013 case of Ventura v. Heirs of Spouses Andaya is enlightening. The court held that in a contract to sell, the fulfillment of the suspensive condition will not automatically transfer ownership to the buyer, although the property may have been previously delivered to him. The prospective seller still has to convey title to the prospective buyer by entering into a contract of absolute sale. Whereas in a contract of sale, the fulfillment of the suspensive condition renders the sale absolute, and the previous delivery of the property has the effect of automatically transferring the seller's ownership or title to the property to the buyer. To help distinguish one contract from the other, the court's ruling in the 1996 case of Coronel v. Court of Appeals is instructive. In said case, the court held that to determine whether an instrument is a contract to sell or a conditional contract of sale, one must determine whether the seller explicitly reserved title over the property until the happening of the suspensive condition or not. If yes, then it is a contract to sell, the breach of which will only make the seller liable for damages. Mindful of the varying legal effects between a contract of sale and a contract to sell, we now turn to the question of why would a party enter into a contract to sell to begin with. In Coronel v. Court of Appeals, the court held that parties opt to enter into a contract to sell instead of a contract of sale because a contract to sell protects the seller against a buyer who intends to buy the property in installment by withholding ownership over the property until the buyer effects full payment thereof. Having established the differences in the legal effects between both contracts, we now ask ourselves, how do we identify a contract to sell? What are the essential stipulations for contracts to sell? There are two. First, reservation of the ownership of the subject matter with the seller, even if there should be delivered thereof to the buyer. Second, reservation of the right of the seller to rescind the contract extrajudicially in the event the suspensive condition does not happen. The currently prevailing doctrine is that absent any stipulation in the deed or in the meeting of minds reserving title over the property to the seller until full payment of the purchase price, and giving the seller the right to unilaterally rescind the contract in case of non-payment, a contract is deemed a contract of conditional sale rather than a contract to sell. As regards the stipulation of reservation of ownership by the seller, jurisprudence is rich with examples. In Chua v. Court of Appeals, the court held that absence of a formal deed of conveyance is a strong indication that parties did not intend immediate transfer of ownership, but only a transfer after full payment of purchase price, especially where seller retained possession of the certificate of title and all other documents relative to the sale until there was full payment of the price. Further, in Nabus versus Pacson, the court held that it is not the title of the contract but its express terms or stipulations that determine the kind of contract entered into by the parties, where the seller promises to execute a deed of absolute sale upon the completion by the buyer of the payment of the price. This shows that seller reserved title to the property until full payment of the purchase price, wherein the contract is only a contract to sell. In the 2010 case of De Leon versus Ong, the court found that a stipulation reserving title to the seller over the subject matter was lacking. Correspondingly, the court noted that the deed executed by the parties did not show that the owner intends to reserve ownership of the properties. The seller executed a notarized deed of absolute sale, turned over the keys, and authorized the loan company to receive payment from the buyer. As regards the second stipulation that provides reservation of the right to extrajudicially rescind in the event of non-fulfillment of the condition, the existence of a provision reserving power on the part of the seller to extrajudicially rescind the contract in the event the buyer failed to pay the purchase price is considered a hallmark that the arrangement is a contract to sell. The court explained this in the 1988 case of Dignos versus Court of Appeals, wherein the court found that where there are no stipulations that the seller reserves the title of the property and the seller acquires it only upon the payment of the purchase price, nor the unilateral right of the seller to rescind the contract, and there is actual delivery of the property, then that contract that the parties enter into is a contract of sale. Now that we know how to identify a contract to sell and how to distinguish it from a contract of sale, we now turn to the remedies available to a party who was injured by another party's non-compliance of its obligations arising from the contract. The remedy of rescission under Article 1191 of the Civil Code cannot apply to mere contracts to sell. In a contract to sell, the payment of the purchase price is a positive suspensive condition, and failure to pay the price agreed upon is not a mere breach, casual or serious, but a situation that prevents the obligations of the vendor to convey title from acquiring an obligatory force. Moreover, the court held in Froilan versus Pan Oriental Shipping Co. that the law does not prohibit the parties from entering into an agreement wherein the violation of the terms of the contract would cause cancellation thereof, even without court intervention. This is precisely because the power to rescind is generally judicial in nature. In a true contract of sale, a provision granting the non-defaulting party a right to rescind would be superfluous because such remedy is inherent for all reciprocal contracts under Article 1191. The power to rescind is given to the injured party only, as rescission is based on a breach of faith. The remedy of rescission must be based on substantial breach as against substantial performance. Rescission is not automatic, thereby requiring a positive act from the party invoking the remedy. What happens when a party avails of restitution? The primary consequence of an effective exercise of the remedy of rescission would be mutual restitution. Under Article 1385, this creates the obligation to return the things which were the object of the contract, together with their fruits and the price with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. As regards the remedies available in a contract to sell, while Article 1191 uses the term rescission, the original term which was used in the Old Civil Code was resolution. Resolution is a principal action which is based on breach of a party, while rescission under Article 1383 is a subsidiary action limited to cases of rescission for lesion under Article 1381. The general rule is that substantial breach and remedies of rescission found in Articles 1191 and 1592 have no application to contracts to sell involving immovable. The exception is on the basis of equity. The Supreme Court has applied equity to contracts to sell in select cases and circumstances. The Supreme Court made equity considerations in two cases. The first is in the 1974 case of Legarda Hermanos v. Saldaña, and the second is in the 1970 case of J.M. Tuazon v. Javier. In Legarda v. Saldaña, the court noted that although the buyer clearly defaulted in his installment payments in a contract to sell covering two parcels of land, the buyer should nevertheless be awarded ownership over one of the two lots jointly purchased by the buyer on the basis that the total amount of installments were paid. The court ruled that there was substantial performance insofar as one of the lots concerned, thereby preventing rescission. In J.M. Tuazon v. Javier, the court noted that where the buyer had religiously been paying monthly installments for 8 years, but even after default he was willing and had offered to pay all the arrears, the court applied equity and granted the buyer an additional period of 60 days from receipt of judgment to make all installment payments in arrears plus interest, although the demand for rescission had already been made. The foregoing rulings show the accommodating attitude of the Supreme Court to buyers of residential real estate who have exhibited a measure of good faith in complying with their obligation to pay even in a contract to sell, as to go beyond form and rules on the effects of non-happening of the suspensive condition to achieve equity based on circumstances present. Whereas in a case where the subject matter is commercial or industrial real estate, the court has maintained a stern adherence for their contract and implemented the legal effects concomitant with such form of contract. What are the minimum requirements for the cancellation of a contract to sell? The prevailing doctrine is that notice of extrajudicial rescission of a contract of sale and cancellation of a contract to sell when the suspensive condition has not been fulfilled require at the very least to be operative notice to the defaulting buyer. The court explained this doctrine in the 1970 case of UP versus De Los Angeles, wherein the court held that it must be understood that the act of a party in treating a contract as cancelled or resolved must be made known to the other and is always provisional, being ever subject to the scrutiny and review of the proper court. The court added in the 1983 case of Palay versus Clave that judicial action for rescission of a contract is not necessary where the contract provides that it may be revoked and cancelled for violation of its terms and conditions. However, even in cited cases, there was at least a written notice sent to the defaulter informing him of the rescission. What form of notice is required for the declaration of cancellation of a contract to sell? In Cabrera v. Isaac, the court held that a letter given to the petitioner's lawyer is also an acceptable form of rescinding the contract. The law does not require notarization for a letter to rescind a contract to sell of immovables. Notarization is only required if a contract of sale is being rescinded. At this point, you should know what is a contract to sell, what are the stipulations that characterize a contract to sell, and what are the remedies available to a party for another party's breach of its obligations arising from the contract to sell. Here are other principles obtained from various court rulings. In Hill v. Court of Appeals, the court held that consignation by the buyer of the purchase price of the property, there having been no previous receipt of a notarial demand for rescission, is sufficient to defeat the right of the seller to demand for a rescission of the deed of absolute sale. In Pan Pacific Industrial Sales v. Court of Appeals, the court held that when a party asks for the resolution or cancellation of a contract, it is implied that he recognizes its existence. A non existent contract cannot be cancelled. We hope you were able to learn a lot. Thank you.